Criminal defense attorneys always advise their clients not to talk to police about a pending criminal matter. You've heard it before, you have the right to remain silent, and you should exercise that right even if you don't believe that you are a suspect in a criminal investigation. It's not made clear to suspects right off the bat that they are the subject of criminal investigations. Often, an individual is led to believe that they are just a state witness and that they can help solve the crime. The likelihood that something may be taken out of context by someone who is unrepresented and talking to investigators is significant. By contacting a qualified criminal defense attorney, you can learn your status in the investigation before talking to police officers. Remember, Florida detectives are trained to obtain evidence that tends to establish the guilt of a suspect, as opposed to gathering evidence that exonerates them. In short, this means that detectives are not attempting to rule you out as being the person that committed a crime. Your silence can never be used against you if a case were to proceed, meaning that charges were filed against you. Oftentimes, criminal defense attorneys come across a case where detectives do not have enough information or evidence to make an arrest, and they'll actually call their number one suspect in to give a statement, leading him or her to believe that they are just assisting with the investigation of a case for which they are not involved in. Police officers are skilled at convincing suspects that it's in their best interest to talk to the police about a crime. And remember, these police officers are often predisposed when investigating a case. If called in to give a statement about a crime, you should always inform detectives that their attorney has advised them not to speak.